Assalamu alaikum. Welcome back to our channel book True Courtroom Stories, researched by Mr. Zahir Ahmad Mir. This is the episode 97 book True Courtroom Stories, researched by Mr. Zahir Ahmad Mir. And welcome back to the deep dive. We are really glad to have you with us today as we peel back the layers of a truly foundational legal principle. It's one of those ideas that dictates the very limits of government power over its citizens.
It really is.
Today's deep dive is centered on some fascinating excerpts from the collection. True Courtroom Stories, researched by Mr. Zahir Ahmad Mir, and specifically a concept that the source calls the immutable shield.
It's a great name for it. The immutable shield is, in formal terms, the principle of legality. Or, if you want the classic Latin, it's nullum crimen sine lege.
No crime without law.
Exactly. It's this incredibly powerful, but on the surface, deceptively simple idea. The idea that you cannot be punished for something you did unless there was a law, a clear and public law, that prohibited that action before you did it.
And that before is everything. That's really the core tension we're diving into today. It taps into a very human fear. What happens when the rules of the game change after you've already made your move? I mean, imagine making business decisions or even just, everyday choices based on the legal rules of Monday, only to find out on Friday that a new law has retroactively declared your Monday actions criminal.
That vulnerability, that uncertainty, it creates instability.
It creates chaos, frankly.
It does. The fear of being penalized, ex post facto, after the fact, is a direct threat to civil liberty. So our mission today is pretty robust. We're going to unpack this powerful principle. We'll look at its deep, deep roots in Islamic jurisprudence, examine a really compelling courtroom story from our source material, and then we'll track its modern guarantees and constitutions across the globe with a special focus on Pakistan's Article 12.
And the goal here is to understand why predictability in law isn't just, a nice procedural thing to have.
Right. It's not a technicality.
It's the essential foundation, the bedrock on which a stable, free civilization is actually built.
Precisely. Went into it.
Okay, let's unpack this concept, the immutable shield.
Yeah.
So the core idea, as you said, is no punishment without prior law. It sounds straightforward, but the critical element here seems to be the temporal one, the timing. Why is the when of a law's existence the single most crucial factor?
The temporal element, the timing, is everything. It's because it defines the entire function of law in a free society. When you demand that a law must exist prior to an action, you ensure that the law functions prospectively.
Prospectively meaning looking forward.
Looking forward, exactly.
Yeah.
It acts as a map or a guide for behavior. It tells you, here are the rules for the road ahead. Now, if a law could be retrospective, meaning it could apply backwards in time,
Then the map is useless. The state is just drawing the map after you've already driven off the cliff.
that's a perfect analogy. The state gains this extraordinary power to essentially manufacture crimes based on political convenience or shifting public opinion long after the actions happened. The requirement of prior existence fundamentally restricts that kind of government overreach. It forces the state to commit to the rules publicly in advance.
The source material puts it very directly. It says this principle strictly prohibits punishment without pre-existing law. And it specifically protects citizens from, and I'm quoting here, arbitrary retroactive justice. We should probably spend some real time on those two words. Arbitrary and retroactive.
We absolutely should. They're doing all the work in that phrase.
Let's start with retroactive. It means the law reaches back in time, often called ex post facto, to govern conduct that's already happened.
Right. And retroactive law just destroys the foundational expectation of stability that people need to live their lives. Think about it. If I entered into a contract last year and it was perfectly legal when I signed it, and then the government passes a new law this year that criminalizes that very transaction.
That new law is retroactive.
It is. It reaches back and completely destabilizes my past actions. It invalidates the good faith reliance I placed on the legal system at the time.
Which is fundamentally unjust.
It has to be.
Yeah.
Because you had no way of knowing you were committing what would one day become an offense. You couldn't have complied with the law that didn't exist.
Okay, so that's the danger of retroactive. Now, what happens when you combine that with arbitrary? Arbitrary means what? Based on whim, not on fixed rules.
Exactly. It's governed by chance or whim or unchecked discretion rather than by fixed, rational principles that apply to everyone. Arbitrary punishment is basically the law being used as a weapon of convenience.
Against specific targets.
Usually, yes. It's law without reason or law applied unevenly depending on who you are, not what you did. And when you combine the two, when punishment is both arbitrary and retroactive, the danger becomes exponential.
How so?
Because the law stops being a predictable guide for everyone and becomes a tool of personalized oppression. The state can literally look back in time, pick a person they don't like, find an action that was legal at the time, and then create a new law to punish them for it.
That's terrifying.
It is. So the ban on arbitrary retroactive justice ensures two things. One, that the rules are fixed and known, and two, that those rules are only applied moving forward. It guarantees the law remains a public, reliable guide.
Can we get a little more nuanced here? I've heard the terms retrospective and retroactive used almost interchangeably. Is there a legal difference?
That's a great question. And yes, there is a subtle but important difference, especially for this deep dive. Generally, retrospective means applying a new law to past events. For example, a new law that says all contracts of this type signed in the last 5 years are now void.
Okay.
Retroactive often implies changing the legal consequences of a past action. So an act was already a crime, but a new law retroactively increases the punishment for it.
So is this principle, this shield, meant to block both?
In criminal law, absolutely.
Mm.
And this is where the strictness of the Nolan Crimen principle really shines. If a law just changes the consequence, say it increases a penalty, that's a retroactive application. It violates the principle because it deprives you of certainty about the cost of your action when you did it.
And if it criminalizes something that used to be legal?
That's a retrospective application.
Yeah.
It violates the principle because you had no notice at all.
So both are barred.
Both strip the citizen of that certainty that is their fundamental right. The shield has to protect against both forms of backward-looking punishment.
This is where it gets really interesting for me. The guiding philosophy, the ratio decidendi. Our source provides this incredibly powerful reasoning. It says, law guides behavior. Punishment cannot rewrite the past.
That's such a profound and concise distillation of the entire concept.
It is. It feels like the philosophical core of the rule of law itself.
I think it is. We have to consider the immense, almost unconscious reliance that citizens place on the existing legal map to navigate their lives.
Every choice we make.
Every single one. Whether it's a huge business merger, taking out a mortgage, building an extension on your house, or even just posting an opinion online. You make those choices inside the context of the current legal framework. That framework is your operational map.
And if the state can just change that map next year and then penalize you today for the choices you made based on the old valid map,
then all of your past conduct is suddenly vulnerable.
and that must go way beyond just criminal law. It seems like it would paralyze future decision-making, which has to have a huge economic and social impact.
Exactly. This is the analytical deep dive. Unpredictability isn't just unfair to one person, it's a systemic shock. If there's no certainty that a contract you sign today will be honored tomorrow, or that an investment you make won't be penalized next month by a sudden law change,
Then why would anyone take a risk?
they wouldn't. Rational economic activity grinds to a halt. Capital is withdrawn. Long-term planning becomes impossible. People shift from being proactive and productive to being reactive and defensive. The economy stagnates because the legal environment, which is the most essential infrastructure for commerce, is unreliable.
But I have to ask the practical question. Doesn't the government sometimes need to correct mistakes or respond to new threats quickly? For example, let's say a company has been exploiting some legal loophole for years, causing massive environmental harm. A new law closes that loophole. Isn't there a huge temptation to penalize the prior behavior to make them pay for the damage?
That is the constant pressure on the system. It's a real and necessary challenge. But the integrity of the principle of legality demands that the answer, when it comes to criminal penalties, must still be no.
Even if the past behavior was, morally reprehensible.
Even then, if the prior action was technically legal, it cannot be criminalized later. The state's remedy has to be forward-looking. New regulations, civil fines, prospective enforcement, sure. But to allow the state to prosecute retroactively, even for a good reason, compromises the predictability that's essential for all citizens.
So you can't sacrifice the foundational rule of notice for the expediency of correcting one past wrong.
You can't, because you would be undermining the legal certainty for everyone, including those who complied in good faith.
This all leads us directly to the moral imperative. The source connects this legal principle to a profound moral lesson. It says, fear of retroactive justice creates tyranny. Predictability creates civilization. That is a very weighty statement about the purpose of law.
It's the ultimate measure of a state's legitimacy, I think. When citizens live in fear that their past can be perpetually relitigated and weaponized against them, the relationship between the people and the government becomes one of permanent distrust.
Apprehend.
Yes, apprehension. And that is the fundamental characteristic of tyranny, where power is exercised arbitrarily, without constraint, often by rewriting history to suit current political needs.
And on the other side of that coin, predictability creates civilization.
Right. When the rules are clear, public, and only applied going forward, it fosters societal trust. It lets people invest and innovate and even dissent without the fear of being punished for choices they made in good faith yesterday.
So that legal certainty is the bedrock. It supports everything from a free press to robust financial markets.
It really does. It shifts the entire judicial framework away from being, say, judge-centric or ruler-centric, where the person in power decides what's an offense after the fact.
And it becomes law-centric.
Exactly. The pre-existing neutral rule becomes paramount. The law is elevated above the momentary passions of the state. And that distinction between having stable rights versus having rights that are contingent on the government's mood, that's the difference between a constitutional republic and an arbitrary regime.
So the immutable shield protects the very idea that you, as a citizen, have a zone of autonomy that the state cannot just arbitrarily penetrate.
No matter how popular the desire to punish a past act might be, the law must be knowable, fixed for the time period in question, and enforced neutrally. That is what separates a functioning legal order from a system of constant fear.
Now, this principle of legality, we often discuss it in the context of Western constitutionalism. It feels very modern. But as our source emphasizes, its roots are ancient and incredibly deep, particularly in Islamic jurisprudence.
That's right.
So let's pivot to that historical anchor. The source quotes a foundational principle. No one is punished until law is declared. That specific phrasing, declared, seems really important. What does that imply beyond just, a rule being written down somewhere?
The word declared is vital. It's absolutely crucial because it addresses the requirement of publicity and intelligibility. In classical Islamic legal philosophy, there's a concept called hujjah. It means the law not only has to exist, but it must be clearly announced, spread around, and understood by the people.
So it can be used as a decisive proof or argument against someone who breaks it.
Precisely. A secret law, or a law that's so obscure nobody can understand it, cannot provide hujjah. And if there's no hujjah, then punishment is fundamentally unjust.
That immediately raises a historical challenge, though, especially in past centuries. How did a legal philosophy like this ensure that a declared law was accessible to a population that might not be literate?
That's a fantastic point, and it really underscores the strength of the principle. Historically declared didn't just mean you had to be able to read a legislative text. It involved public proclamation.
Like a town crier.
Exactly. Town criers, judicial pronouncements in the central marketplace, or dissemination through established religious and community leaders who would explain the rulings and decisions. The law had to be brought to the common person in a form they could actually understand. This historical practice shows a proactive duty on the governing body to ensure clarity and public access.
So the requirement for a law to exist beforehand and the requirement for it to be clear, they're really two sides of the same ethical coin.
They're completely intertwined. If the law hasn't been declared, or if it's so complex and contradictory that an average person can't reasonably be expected to understand it,
then the hujjah against them for violating it is weak or non-existent.
it's non-existent.
Yeah.
This ties directly to fairness and personal responsibility. You can only be held accountable for actions you knew or reasonably should have known were forbidden because the prohibition was announced clearly and publicly.
This long historical lineage proves that the non-retroactivity principle isn't some recent invention. It's a universal moral requirement for justice.
It truly is.
Okay, let's bring this down from the philosophical to the concrete. Let's use the case narrative provided in the source material. This story makes the whole principle tangible. It shows the immutable shield in action.
It does. It connects the ancient principle directly to modern court practice.
The facts are simple but very compelling. A man was accused under a newly announced rule for conduct that had occurred earlier.
This is the perfect, almost clinical example of the conflict we've been talking about. The state, or maybe an opposing party, is trying to apply a current rule backward in time. Maybe they believe the conduct was inherently bad, even if it was technically legal when it happened.
And the judge, in this critical moment, has to be the one to step in.
Yes. The judge has to prevent the law from being used as a temporal weapon.
The power of the story is all in the judge's refusal and the logic behind it. The judge focused on a few distinct points. The first one was the requirement of preexistence.
The judge establishes a rigid, unbreakable timeline. Event A, the enactment of the law, must happen before Event B, the prohibited conduct. Period. If that timeline is violated, the prosecution simply cannot stand. The judge is prioritizing the procedural integrity of the law, the requirement of notice over the immediate desire to punish someone.
It's a declaration that the legal system runs on codified pre-existing facts, not on what we wish the law had been.
Exactly, not on subsequent regret or evolving social norms.
I have to ask, though, what if the judge personally felt the action, even if it was legal at the time, was morally egregious? What if it caused obvious public harm? Does the principle of legality force a judge to let someone go who they know caused real damage?
It does. And that is where judicial courage comes into play. The judge is constrained by the law as it was, not by their personal moral judgment. If the existing statutes at the time did not cover the action, the judge's duty is clear. Uphold the principle of legality.
To do anything else would be.
It would be to engage in the very same retroactive justice that destroys predictability. The system has to accept the lesser injustice of letting a harmful but legal past act go unpunished.
Rather than commit the greater injustice of undermining legal certainty for everyone.
That's the trade-off. A difficult one, but a necessary one for a free society.
That sets up the judge's second point perfectly, which was the characterization of harm. The judge explicitly called retroactive punishment oppression. That's not a legal term of art, that's a judicial condemnation.
It's a profound statement. As you say, oppression isn't a technical term. It's a moral and ethical judgment. It implies a gross misuse of state power. By labeling retrospective justice as oppression, the judge is signaling that applying a law backwards isn't a simple procedural mistake. It's an act that violates the fundamental relationship between the citizen and the state.
It turns the judiciary from just an executor of state policy
Into a protector of fundamental liberty. This connects directly back to that moral lesson. This kind of action breeds tyranny, even if it's just carried out by a single judge in a single case.
And the third essential pillar of the judge's refusal was the necessity of certainty. The judge said that justice requires predictability. So predictability isn't just a desirable quality, it's a fundamental requirement.
This is the judge asserting the judiciary's foundational role. Predictability gives the citizen their defensive shield. The judge is effectively saying, my job is to enforce the law as a predictable system. Without that, the citizen is perpetually guessing, perpetually vulnerable to the shifting will of the government.
The court's refusal here guarantees that the rules of the game remain fixed.
They do.
For you, the listener, this courtroom story provides immediate reassurance. That decision is the immutable shield in action.
It is. The individual in that case moves from the terrifying ambiguity of arbitrary punishment to the security of knowing their rights are protected by a deep, universal principle of justice.
It's a reaffirmation that the law is designed to constrain the state's power, not just to facilitate it.
And this case, from the source material, proves that this ancient principle, the requirement for prior, declared law, is still the immediate practical mandate for every modern judicial officer who is committed to fairness. The temporal integrity of the law is simply non-negotiable.
So we've established the principle's ethical and historical weight, and we've seen it applied in a real courtroom scenario. Now let's transition to the global stage. Let's show that this concept isn't unique to one system, but it's a universal requirement for modern justice.
This global consensus is what makes the principle so powerful. It shows that legal systems that evolve from completely different traditions, common law, continental law, religious law, they all converge on the exact same conclusion.
Which is?
That a just state cannot operate retrospectively when it comes to punishment. This convergence highlights that legal security is a universal human imperative.
Let's start with the European parallel. Nullum crimen sine lege. We mentioned the Latin earlier, no crime without law. This is the explicit articulation of the principle in the Western tradition, and it underpins most European jurisprudence.
It does. And the strength of nullum crimen sine lege lies in its two related parts, which work together to ensure comprehensive protection. First, there can be no crime without law. This means the conduct itself must be clearly defined as prohibited beforehand.
And the second part.
Second, there can be no punishment without statute. This guarantees that the severity and type of penalty must also be legally prescribed in advance.
That first component, no crime without law, that prevents vague general accusations, right? The state can't just say, you acted in a generally bad way.
Exactly. It demands specificity. There's another Latin term for it, lex certa. The law must be certain.
It forces the legislature to be precise.
It does. It prevents them from writing laws that are so broad or so vague that prosecutors or judges can creatively interpret them to cover unforeseen acts after the fact.
And the second component about the punishment is just as crucial.
Just as crucial, because it prevents a judge or an executive from arbitrarily imposing some novel or excessive penalty just because a past act seems especially heinous in retrospect. The certainty has to cover both the prohibition and the consequence.
This detailed analysis leads to a fundamental conclusion, one drawn from this principle in European and international law, which is that legal certainty is a human right. This elevates the entire discussion. We're moving from a procedural rule to an essential part of human dignity.
This is perhaps the most significant intellectual step in the modern era for this principle. When you classify legal certainty as a human right, it gains a powerful, almost non-derogable status.
What does that mean in practice?
It means that even if a parliament passes a law with overwhelming popular support, if that law violates the core principle of non-retroactivity, it can be overturned on fundamental human rights grounds. It becomes a standard of behavior for the state itself.
So what are the practical implications of that? What mechanisms or obligations are activated when a principle gets elevated to human rights status?
Several key obligations are activated. First, it imposes a positive duty on the state to make its laws intelligible, accessible, and foreseeable.
They have to be published promptly, written clearly.
In a manner that citizens can actually understand. This ties back perfectly to that ancient concept of declared law we talked about earlier.
And for the courts?
For the courts, it provides judicial review with immense teeth. Judges are empowered to strike down laws that are vague or potentially retrospective, knowing they are protecting a fundamental right, not just a procedural preference. And finally, it allows citizens to appeal to international bodies, like the European Court of Human Rights, if their own domestic courts fail to uphold this principle. It's a much higher level of protection against state tyranny.
Now let's bring this home to the specific context of our source material. We see this exact principle codified explicitly in the Pakistan parallel, Article 12 of the Constitution. This provision is the specific constitutional framework that enforces the principle of legality. It's the mandate for the kind of judicial courage we saw in that courtroom story.
Article 12 is comprehensive and it's powerful. It essentially imports the entire nullum crimen shield directly into the foundational law of Pakistan. It details two specific prohibitions that ensure certainty. First, the prohibition of retrospective criminal liability, and second, the prohibition of ex post facto punishment.
Let's quickly elaborate on that distinction one more time because it's so key. Retrospective criminal liability means you can't make yesterday's legal action a crime today.
Correct.
And the prohibition of ex post facto punishment covers situations where the crime already existed, but the state tries to increase the penalty after the fact.
And that nuance is crucial for everyone to grasp. Let's say a person commits theft at a time when the law says the maximum penalty is 1 year in prison.
Okay.
2 months later, before they're convicted, the law is changed to set the maximum penalty at 5 years. The ex post facto clause ensures that person can only be sentenced up to the 1 year maximum because that was the legally prescribed consequence at the time they committed the offense. The law cannot retroactively make the consequences worse.
So predictability applies equally to the gravity of the penalty as it does to the definition of the crime itself. Now, our source notes a critical detail here. It says that courts enforce Article 12 strictly. To do that, they have to constantly differentiate between substantive law and procedural law. Why is that distinction so important, and how does it prevent the state from finding a loophole in Article 12?
This is the legal tightrope the judges have to walk. And it's critical. They have to make this distinction because the principle of legality applies strictly to substantive law.
Which is?
Laws that define our rights, our obligations, crimes, and punishments. Those cannot be applied retrospectively. However, procedural laws, the laws that govern the mechanics of a trial, like rules of evidence or which court has jurisdiction or filing deadlines, those can often be applied to ongoing cases, even if the case is about past conduct.
So if a new law just changes which courthouse hears the case, that's generally okay because it doesn't alter the definition of the crime or the potential punishment.
Exactly. But here's the danger. The state may be desperate to apply a new penalty, might try to cleverly label a substantive change, like a new mandatory minimum sentence, as procedural to try and get around Article 12.
Ah, I see.
Strict enforcement means the courts must look past the label the legislature puts on the law and assess its practical effect. If the new law fundamentally prejudices the accused or alters the legal elements of the crime or increases the severity of the punishment that was in place at the time of the conduct, the court has to recognize it as substantive and strike down its retrospective application under Article 12.
That strict policing is the firewall.
It is.
And that brings us right back to judicial courage. The judge has to be willing to stand against the immediate demands of the state, maybe even against public opinion, to uphold this foundational long-term principle.
That's right. Strict enforcement of Article 12 ensures that the immutable shield remains a practical defense, not just some fine-sounding constitutional rhetoric. It is the ultimate check.
By rigidly enforcing this non-retroactivity clause, the judiciary sends a clear message.
It's a message that the legislative and executive branches are bound by the same rule that guarantees civil liberty for everyone. The law must always face forward. It guarantees that the predictability needed for a stable society is legally mandated, universally accepted, and judicially protected.
We've taken a truly deep dive today. We followed the principle of legality from the ethical commands in Islamic jurisprudence through the universal language of nullum crimen sine lege, and finally to its concrete constitutional guarantee in Article 12. The journey reveals a singular, universally accepted shield against arbitrary state power. It confirms its truly immutable nature.
The consistency across all these different legal traditions is just astonishing, really. Whether you're discussing the historical requirement for declared law or the modern classification of legal certainty as a human right, the core idea is the same.
The state has to provide predictability.
Predictability, transparency, and a strict adherence to a timeline. This principle isn't some technical loophole for criminals. It is the ultimate protection for every single citizen who relies on the stability of the law to make rational, long-term choices.
Let's return to that moral lesson one last time, emphasizing that crucial dichotomy from the source material. Predictability fosters trust, stability, and civilization, while the potential for retroactive law breeds tyranny and fear.
And it really is a measure of a just society. A society that respects the principle of legality is fundamentally signaling its commitment to individual autonomy and dignity.
It's making a promise.
It's making a promise that the rules of engagement are fixed and knowable at the moment you act. That promise is the essence of a modern, stable state where the relationship between the government and the governed is based on transparent rights and judicial constraints, not on the shifting sands of political power.
The enforcement of this shield really is the litmus test for whether a system values stability and fairness over expediency.
I couldn't agree more.
This entire analysis leads us to a compelling final thought. A friction point that builds directly on everything we've discussed, but forces us to look ahead to the immediate future. If the law must always precede conduct, if that temporal element is absolutely sacrosanct, what happens in rapidly evolving fields where harmful conduct might emerge before lawmakers have time to draft a clear, explicit statute?
This is the critical contemporary challenge to the whole principle. Think about the rise of deepfake technology, or complex, decentralized autonomous organizations, DAOs in finance, or new forms of algorithmic market manipulation.
New harms can appear and scale globally in a matter of months.
Exactly. And the legislative process often takes years to draft clear, explicit, and constitutionally sound statutes. This tension puts immense pressure on the principle of legality.
So if lawmakers rush to legislate, they risk writing laws that are too broad or too vague.
And they violate the principle of clarity, the lex certa, that's inherent in nullum crimen. But if they wait for perfect clarity, the harms just multiply unchecked.
Let's take an example. A new form of crypto fraud appears that doesn't neatly fit the definition of securities fraud or bank fraud, as it was written in, say, 1934. Can the courts just expansively interpret the old statute to cover the new harm?
That is the precise ethical and legal dilemma. If a court stretches the definition of bank fraud so far beyond its original clear boundaries to catch a new decentralized finance crime, is that just judicial evolution?
Or is it a form of quasi-retroactivity?
Exactly. Is it penalizing conduct that a rational person, relying on the plain text of the old law, could not possibly have foreseen was criminal? The judiciary has to resist the temptation to become a retroactive legislator.
So they have to ensure the law remains relevant, but they cannot make up new crimes after the fact.
That's the balance. It requires creativity in legal design, maybe implementing regulatory bodies with flexible but prospective rulemaking capabilities that operate transparently.
But always with the absolute constraint that citizens must have clear pre-existing notice of what is prohibited. That immutable shield cannot be dropped, even in the face of a technological revolution.
The challenge is making the law agile without making it unpredictable. It forces us to ask, are we legislating to govern current action, or are we legislating to punish past behavior?
And the principle of legality firmly and always mandates the former.
Always.
A truly profound thought experiment for our listeners to think about. How do we keep the law predictable when reality itself is changing at warp speed? That's the challenge for the next generation of legal thinkers. Thank you for joining us on this deep dive into the immutable shield, the principle of legality, drawn from the compelling insights in True Courtroom Stories researched by Mr. Zahir Ahmad Mir. We encourage you to explore further the philosophical and constitutional foundations of justice.
Until next time, stay informed and continue demanding certainty and clarity from the laws that govern your civilization.